Good morning, PyCon. I'm always happy to see that fraction of the conference which does make it in for the third morning successfully. Glad you're all safely arrived. This is the last day of the main conference. 4 days of sprints follow, but at this point we are hurtling towards the conclusion of the main conference. Two talks this morning. We'll all head over to the expo hall, which the expo hall that you knew yesterday, it's gone. It's disappeared and been replaced by a different expo hall where we will get to see our poster presenters giving their poster presentations. You'll get to wander amongst them and talk to them and interact with them as you're interested in their subjects. And the job fair will also be kicking off, followed by lunch, followed by the very last few talks of PyCon 2016, followed by our closing keynote and farewell. So just a few last things here. Take advantage of them, pay attention, interact with each other because we're coming close to our end. On this last morning, we're going to start by hearing from the chair of the Python Software Foundation, the nonprofit that owns the intellectual property and the trademarks of the Python programming language that is careful to make it so that no one person owns that copyright, but an organization that might outlive us all will be the curator of what the community has created together in fashioning and implementing this language. And so I'm very happy this morning to introduce the person in charge this year of the Python Software Foundation, Chairman Van Lindberg.
I am super happy to be here today. It is not nearly as full, which actually makes me very comfortable. I remember the first day that this place was packed to the gills. You know, this has been a magnificent conference, and I have to say that thanks to Brandon, I have played more games of Oregon Trail this past year than in like the past 25 years combined. I have been preparing my way to come to the Willamette Valley. So I wanted to do things a little bit differently today. The first thing is that we frequently talk about the community, but today I wanted to take a few minutes first and recognize some people who make our community different and better. And to do that, I wanted to have some assistance from Eva Jadlowska. Eva, if you could come up. How many people here know Eva? Eva has been behind every PyCon since Chicago. And several years ago, she joined the PSF and has become our director of operations. If you interact with PyCon, if you interact with the PSF, you have interacted with Eva and the things that she has done and the things that she has touched. So I wanted to give her a couple minutes. I'll turn the time over to her.
Good morning, everyone. Thanks for being here on our last day. In case no one knows, that's how you can contact me, my email address and Twitter handle. Sorry, it's a little long. So as of yesterday, the PSF membership has voted in a new board for the Python Software Foundation. I would like to welcome the new board of directors and welcome back the ones that have served previous years. So let's give them a round of applause. And since Brett is so important to our community here, I thought that this award deserved another mention. So given at OSCON every year, the Frank Willison Memorial Award for contributions to the Python community is given annually to a person judged to have an outstanding contribution to the Python community. And this year, it is Brett Cannon. Thank you, Brett, for all the work that you've done. Yeah, he's over there. Woo! Furthermore, as Van mentioned, the PSF acknowledges volunteers who make a significant contribution to the Python community. Here's a list of all the awardees since PyCon 2015. These people have received the Community Service Award, and some of them are here, so if you do run into them, make sure you tell them thanks. Thank you, everyone. Lastly, I would like to recognize one other person and service that the PSF supports. How many of you here use PyPI? Woo, that's a lot. Donald is one of the main forces behind maintaining and improving PyPI. Unfortunately, Donald Stuff could not be here at PyCon this year, but he will definitely try to be here next year. And he has written this awesome blog post. The link is up here. And if you haven't had a chance to read it yet, please take a few minutes later on today to go through it. He writes about the volunteer involvement and the sponsor involvement and donations that the PSF receives to keep PyPI running. As the value and the interest of PyPI grows, we need to make sure that PyPI has longevity. In response to Donald's blog, the main question that we have received is, how can I help? In response to that question, one of the things we've done is create a donation page. So there's the link to the donation page. For those individuals and companies who can support the PSF in this mission and support the longevity of PyPI, please go to this link and donate and help us spread the link on Twitter. It'll help us make sure that we have the resources to keep PyPI going. Thank you, everyone.
So, up until last week, I was going to give a completely different talk. And on Thursday, something happened that I thought, I'm just going to round file everything I was going to talk about, and I'm going to talk about this. So today, I'm actually going to put on my IP lawyer hat. It's one of the hats that I wear. And I'm going to talk about the Google-Oracle decision. So last week, there was a victory for Google in the 6-year-long legal battle that has been going on between Oracle and Google about the use of Java language as an input to the Android runtime. Oracle first filed the suit in 2010, and they alleged both patent and copyright infringement. In 2012, the first jury trial found that Google didn't infringe any of the patents, but they did find that Google infringed the Oracle's copyright on the 8 Java APIs. Whoa, why is this going so fast? In that first trial, however, the judge overruled the jury and found that the API could not be copyrighted as a matter of law. So Oracle appealed this decision to the Federal Circuit, who reversed the trial court's decision, and they said that the Java API was sufficiently expressive to warrant copyright protection. But instead of just saying, Oracle, yes, you win, the appeals court sent the case back down to the trial court to try the case again on the subject of fair use. Last week, this second trial ended, and the jury found that Google's incorporation of the APIs into Android was covered by fair use. So one question that I got from a few people was, why do we even care about this? Aren't software patents actually the big issue? And Google won over the software patents in the first trial. Well, I actually think that the copyright here is more important. Yes, there's a lot of shenanigans going on with patents. But copyright is the foundation both of commerce and software, and actually of the foundations of free and open source software as well. Copyright is probably the most difficult and the most subtle of the 4 main branches of intellectual property. And the reason why is, even though there are some aspects of the patent documents and patent practice that are more complex and intricate, the underlying bargain that surrounds patents is relatively simple. If you are an inventor, if you create a new thing, then you describe to the public how it works. In return, you get the exclusive use of your invention for a period of time. After the end of that period, well, everyone else gets to use it as well. Everyone else gets to use it, and you have been compensated, or at least you have had the opportunity. Copyright is superficially similar, but actually fundamentally different. Yes, it is part of this bargain that says, yes, if you create this new expression, you are going to have the opportunity to have exclusive control over it for a period of time. But that period of time is measured in centuries, not in years, really. It's about a century, depending on how it works. The second thing is that there are two fundamental differences between patents and copyrights. The first is that patents cover function and copyrights cover expression. The second is that nothing is patented by default, but almost everything is copyrighted by default. So, what does it mean not almost everything is copyrighted? Well, not everything is copyrightable. And this goes to the core of what was at issue in the first trial and in the appellate court. There are a few important exceptions. The copyright statute says, and I quote, "In no case does copyright protection for an original work of authorship extend to any idea, procedure, process, system, method of operation, concept, principle, or discovery, regardless of the form in which it is described, explained, illustrated, or embodied in such a work." Think of it this way. You can't copyright a machine. And so, in the first trial, Judge Alsop decided that the APIs were much more like a machine than they were like a novel. He said, quote, "So long as the specific code used to implement a method is different, anyone is free under the Copyright Act to write his or her own code to carry out exactly the same function or specification of any methods used in the Java API. It does not mention that the declaration or method header lines are identical." Unquote. Moreover, the underlying structure, sequence, and organization of the API, or what they used in the parlance of this case, the SSO, they said it was not copyrightable because it was one of these systems of operation. So let me be specific for a moment what I mean about an API. This is about the method signatures used in the Java API, as well as the structure, sequence, and organization that I was saying. To compare to Python, this is equivalent to the names of all the built-ins, the functions of the signatures of the built-ins, the names of the modules in the standard library, and the function signatures of all their exported functions. This excludes all of the, quote, implementing code. Basically, that's all the code that's actually hard to write, that actually does the stuff that we're talking about. This is solely about those names and labels. The appellate court that reviewed the trial decision, the Federal Circuit, overruled the judge and decided that this structure, sequence, and organization, the collection of labels and function signatures, was sufficiently expressive to be copyrightable. And so a lot of people said, when this came out, they said, didn't the appellate court get it wrong? No, I don't think they did. I think they got it wrong on the policy. I think that their thinking was fairly muddled. But ultimately, I believe they actually got it right on the law as it currently stands. As much as we would like there to be a bright line rule that says any re-implementation of any API is never going to be copyrightable, we don't necessarily want to get into the place that's saying, hey, this is an API, therefore it is categorically excluded from copyright. That's probably not correct. Is there no expression or no creativity in APIs? What about places, for example, where you have header macros, where you have substantial amounts of cleverness or things that go into the API that make it easier to use? I wrote something 9 years ago, and I was happy to see that I called this correctly. I said, an individual name or symbol in a header file cannot be copyrighted, but the particular selection of symbols may be. The selection of symbols to be exported is inherent to API design, which could be a copyrightable creative decision. If you've ever heard programmers talking about beautiful or ugly APIs, you've wandered into the tricky middle ground of barely copyrightable expression. In my opinion, the most likely scenario, in case this was litigated, is a case-by-case determination. A bunch of constants would probably not support copyright, but the entirety of an exported API is more likely copyrightable. That said, I do want to criticize the underlying policy behind the Federal Circuit decision. They found it is important to uphold copyright. But they didn't, I think, properly understand all the underlying policy issues, and that is the public interest that is served through the making of a particular decision. The policy should have been that a bright line rule is the best one, because bright line rules allow people to easily reason about and understand where the boundaries are between what they can do and what they can't. It would have been better for innovation if they had had that rule. But that's not what they chose. Instead, they said, this is copyrightable, but it still may be okay under the doctrine of fair use. So what is fair use? It is a statutory exception to the enforceability of a copyright. The underlying expression is still copyrighted and is still protected under that law, but there are certain uses that we as a society have said are so important that we are going to allow them regardless of whether the copyright owner says so or not. And in particular, there are the copyright statute says, quote, fair use of a copyrighted work for purposes such as criticism, comment, news reporting, teaching, scholarship, or research is not an infringement of copyright. In determining whether the use made of a work in any particular case is a fair use, the factors to be considered shall include purpose and character of the use, including whether it's commercial nature, the nature of a copyrighted work, the amount and substantiality of the portion used, and the effect of the use upon the potential market or value of the copyrighted work. I cut a little bit there, but unquote. These four factors are not exclusive. You'll notice it says they shall consider these and other things. In practice, these are the four factors, and these are the only ones that are effectively analyzed in any of the cases about fair use. And it goes farther than that because typically the first and the fourth factors are really the ones that have the most weight. If you are a commercial entity profiting from someone else's copyright, or you are affecting the ability of the copyright owner to monetarily receive the rewards of their work, courts have found, and not unreasonably, that is the thing that really frequently separates a fair use from an unfair use. The reason why this was such a close case is because what Google was doing does not fit clearly into any of these exceptions. In this case, both sides all argued all four factors. But what is unusual about this case is that this will probably go down as being one of the key cases on the second factor, that is, the nature of the copyrighted work. So I said that there was a jury decision, Google won. Everyone wanted to know, did the jury tell us what they thought, exactly why they decided this? And the answer is unfortunately no. This is the entirety of the communication that we got back from the jury. The lawyers on both sides spent hours and hours, each side had 900 minutes, trying to explain to a bunch of non-programmers what APIs are. They tried everything to say, this is like a painting, this is like a filing cabinet. They had a filing cabinet in the courtroom for most of the trial. we don't know whether they ultimately got it or not. And unless one of these jurors ends up speaking to the press, we'll never know. So everyone, at least almost everyone in the tech world, promptly jumped up and started celebrating. Yay, this is great. And they thought, now we can re-implement APIs, can't we? Well, no, you can't. Assuming that the current decision stands, all that it means is that it was legal for Google to use Oracle's Java API in Android. That's it. The holding is very specific to this particular case. And what's more, due to some of the wrinkles in the way in which appellate courts hear cases, this case doesn't set precedent for any other court in the country. Even in California, where the case was heard. At best, it is what is called persuasive authority, i.e., this is a case where someone else, some other court, has thought about a particular issue, and they are going to discuss it, and it may be persuasive, it may not. Other courts don't have to agree, though. I also want to get back to that idea of policy. Remember how I said that I believe that the appellate court got it wrong on the policy? A bright line test about copyrightability makes it easy for others to apply the test in the same way and reach the same conclusion. Fair use, on the other hand, is by design a case-by-case determination. That means that you may think that you are doing the same thing as Google and that your use would ultimately be judged fair, but you do not know until you've actually gone through the court. And trust me, you don't want to do that. In short, this decision is technically good for one use only. But if this is good for one use only, then why do we even care? Well, there are three big reasons why this decision is important. First, a decision that went the other way, that APIs are copyrightable, would have had much broader impact than the current finding that it was covered by fair use. This is because at one stroke, companies that controlled important and popular APIs would wield patent-like power over all implementations of that API. If you can think about that and think of how many APIs that we use and interact with, that would be a huge disruption. The second is that cases like this don't come along very often. This case will set the tone for many court cases and many negotiations that will take place over the next 10, 15, or 20 years. And so even though this is not technically going to be precedential for anyone, the fact that it was so high profile and so well litigated on both sides, and I don't necessarily mean that in terms of quality, I mean more that's in terms of quantity. Everyone brought out their arguments. This is going to make it incrementally more likely that lots of new companies over the next couple decades are going to have the ability to make fair use of APIs and other things, bringing new capabilities and new services to society. That's important. Finally, and most practically, this would have a decision the other way would have opened up a good chunk of the entire United States to liability. Once a court has found that something infringes copyright, then anyone who's distributing it or copying the infringing item is also infringing. It's a strict liability type of thing. You're doing it, it's copyright infringement, done. This would have been an extinction-level event for Android, and with all the disruption that would entail. So when this came out, there were a lot of people commenting, and the majority of the people said, this is good, this is a big one for Google, this is important for developers and for software. But there was one person in particular who wrote an op-ed that said, this decision is the death of free software. That person was someone who was very well acquainted with this case. It was Annette Hurst, who happened to be Oracle's lead trial counsel. She said, quote, "While we don't know what ultimately swayed the jury, Google's narrative boiled down to this. Because the Java APIs have been open, any use of them was justified, and all licensing restrictions should be disregarded. In other words, if you offer your software on an open and free basis, any use is fair use." Quote. You know, I honestly believe that she meant those words when she wrote them. I also think that she's just completely and utterly wrong. It is true that Google made a big deal in the court about how Oracle, and previously Sun, had set out that these APIs were free and open for anyone to use. But that was in the context of arguing about the purpose and the character of the use, i.e., factor one of the fair use factors, not in the sense that this was applied and that this was licensed under an open source software license. I don't believe that anyone in Sun or later Oracle ever thought that offering something as free and open source software was saying that you completely could ignore the underlying license restrictions. In fact, I know that they didn't because I had to go up against Oracle when they were fighting about this in a separate thing. Sun's counsel at the time was very savvy. They knew how open source worked, and they weren't surprised. So, one last thing that I think that we should all learn from this case is that it doesn't always pay to mouth off on the internet or on internal mailing lists. Go to almost any Hacker News discussion or Reddit or, your watering hole of choice. And one of the things that you will see almost always when a legal issue comes up is someone will say, "I'm not a lawyer, IANIO. But," and they'll proceed to hold forth on a legal topic, usually incorrectly. Well, 10 years ago, a whole bunch of developers on the Apache Harmony mailing list and inside of Google did just this thing. And they held forth on their opinions about the copyrightability of the APIs, or they mixed up trademark and copyright, or they did various things like that. And a number of these engineers were subsequently called to the stand and were grilled about, what is your knowledge of copyright law? While their emails were projected in large type over their head. When you're coming to one of these situations, if you really know what you're talking about, and you know that you know what you're talking about, sure, that's okay. But if you don't, just don't. So finally, is this over? Are we done? It's 6 years. No, it's not. First, this judgment is not yet final. It'll probably will be within a month. And Oracle has already indicated that they will appeal. They may even win on appeal. It's going to be harder, but I'd give it maybe a 33% chance. But I'll conclude with the following. Perhaps it may not be obvious. I prefer the current outcome, and I hope it sticks. But I think that one of the most powerful things that could ever happen to free and open source software would be if Oracle wins. Why is that? Because businesses all over the United States would suddenly take a look, and they would find all these APIs that they rely on. All of a sudden, where they thought that they were free and they were covered, they would see massive amounts of legal risk and massive amounts of financial risk. And all over, they would make an immediate pivot to APIs that they knew had wide permission for use and rock solid guarantees about how that was used. In other words, open source. We will see. Thank you.